Good morning, everyone, and welcome to the 24th meeting of the Justice Committee in 2020. We have apologies this morning from Shona Robertson, MSP. The first item on our agenda is to agree to take items 3, 5 and 6 in private. Our members agreed. Members are agreed, thank you. Our next item is to consider at stage 1 the Culpable Homicide Scotland Bill, and I refer members to papers 1 and 2 in our pack. And I welcome our panel of witnesses who are both attending online this morning: Claire Baker, MSP, the member in charge of the bill, and Patrick Maguire, a solicitor from Thompson's. Welcome, Claire, and welcome, Patrick. Thank you for joining us this morning. And I invite, first of all, Claire Baker to make some short opening remarks, and then we'll proceed straight to questions from there. And Rona Mackay will ask the first question. But Claire, an opening remark from you about the bill, please.
Good morning, Convener. Thank you very much to the committee for inviting me along to give evidence on the Culpable Homicide Scotland Bill. This is not the first time the Scottish Parliament or the Scottish Government has been asked to consider this law when an individual's death is caused by a business or an association. Scottish Government ministers have previously commissioned analysis and expert groups. The UK Government introduced the Corporate Manslaughter and Corporate Homicide Act 2007, of which there has been no convictions in Scotland. And this is the third proposal for a Members' Bill seeking to address an injustice that has not gone away. While we have failed to tackle this issue, the most recent annual average is 19 people per year are killed in Scotland while at work, the highest rate in the UK, which are investigated by the Health and Safety Executive. The most recent figure is that there were 29 deaths in 2018-19. This does not include deaths investigated by the Marine Accident Investigation Branch, the Air Accidents Investigation Branch, the Office of Rail and Road, or work-related road traffic incidents. I believe we must take action to address this poor record of fatalities and provide a route to families for justice by using the powers of the Scottish Parliament to ensure culpable homicide is applied to individuals, small businesses and large businesses and corporations equally. I have spoken to families who have suffered the pain of losing a loved one at work. When they said goodbye in the morning, they did not expect that to be the last time they saw their mother, their father, their son. They have shared with me their frustration at the justice system, which they believe does not fully recognise the responsibility and accountability of the employer. While health and safety legislation can be enacted to issue fines, and in rare circumstances a custodial sentence, it is not possible to use the current laws to effectively pursue a culpable homicide case through the criminal courts. This bill would make that possible. I would also argue that the bill is a positive lever which will improve health and safety practices within the workplace. This legislation will ensure that the consequences for companies, big or small, who fail to implement and maintain good health and safety standards, putting their employees at risk, will be significant and will reflect the seriousness of fatalities at work. This will act as a strong incentive for employers to be confident that they do operate a safe and responsible business. The bill has the support of the STUC and trade unions with direct experience of their members experiencing injury and fatalities in the workplace. I would like to thank Scottish Hazards and Patrick Maguire from Thompson's for their valuable support and expertise, along with Families Against Corporate Killing, who from a place of great loss have long campaigned on this issue. There is a strong desire to close the recognised loophole in our current arrangement. Families who have lost a loved one at work feel they do not have access to justice, and I believe the time has come for the Scottish Parliament to take action.
Thank you, Claire. That's very clear and very helpful. Rona Mackay is going to open the questions for us, and after Rona, it'll be James Kelly. But Rona first, please.
Thank you, Convener. Good morning, Claire, and good morning, Patrick. Claire, I wonder if you could expand a wee bit on the background to your bill, just in very general terms, and what prompted you to bring it forward. As you say, it's not the first time the bill's been brought forward. So if you could just expand a wee bit on why you feel so passionate about it.
Well, as the Mackay has mentioned, it's not the first time, and Karen Gillan first brought forward the bill. Karen represented Lark Hall, where we had the tragedy of the Lark Hall explosion, which Transco was responsible for, and it was recognised at that Lark Hall, where we had the tragedy of the Lark Hall explosion, which Transco was responsible for. Recognised at that time there was a loophole in the law, as the sheriff believes there should have been opportunities. A couple homicide case was brought forward, and Transco should have been held responsible for that in that way. but the law didn't enable that to happen and the case collapsed. That was the initial response. And my involvement comes from having met families against corporate killing and the activists who are campaigning for change. And if we look at the 2007 legislation that was passed by the UK Parliament, as I said, there have been no convictions in Scotland under that law. And if we look at the numbers of deaths that there are in Scotland, we had a particular peak in the most recent year, but we're still looking at 19 on average a year. That figure has not changed since the 2007 Act. If anything, it's actually got worse. And the way in which they're dealt with, we've estimated that there are, under that time, there's been some 250 cases, but only some 9 convictions. So it's very difficult to take forward prosecutions in this area, and there has been no prosecutions under the 2007 Act. So the current law, I think, is ineffective, and there's also the issue of equality. It is possible for an individual to be charged with culpable homicide, and it would be possible for a small business in Scotland to be charged with culpable homicide, because the cases I think the government have stated have included examples such as the skipper of a shipping fleet. It's easy to identify that person, but when it comes to a large business, there's a loophole. There's no way for that to be pursued through the courts, and the legislation seeks to address that.
Okay, thank you, Claire. Thank you, Convener.
Thank you very much, Claire. In your answer to Rona there, you said that there have been no prosecutions in Scotland under the 2007 Act. In your opening remarks, you said there have been no convictions under that Act. Is it true that there have been no, I accept there have been no convictions, is it also true that there have been no prosecutions brought under that Act in Scotland?
Yeah, Convener, my understanding has there has been no prosecutions under that Act in Scotland. There have been a handful in England, but they have been small businesses. They have been small construction firms where the manager has been prosecuted under the Act, but there hasn't been any in Scotland.
Thank you. Thank you. I just wanted that to be clarified. Thank you very much for that. James Kelly, please.
Thank you, Convener, and good morning to Claire Baker and Patrick Maguire. Can I declare an interest as someone who's signed and support Claire Baker's bill? And can I just ask Claire Baker, what specifically are you trying to address here with this legislation? What gap in the legislation do you think exists that this legislation needs, or this proposed legislation needs to be brought forward?
I think there are a few areas. Again, the issue of inequality, the way in which the law acts in Scotland, you can, a person can be charged with culpable homicide, an individual, a small business could, but a large business can't. And if we go back to the Transco case, at the time the sheriff did wish to take forward a culpable homicide case, and that collapsed. And I think while you can have legislation, you can have prosecutions under health and safety legislation, and fines can be issued, and occasionally a custodial sentence, families don't feel that is sufficient for what they have gone through, and doesn't recognise the recklessness and the gross negligence of the way in which a country has operated that has led to that death. And I do also have concerns that while in Scotland we had, there's also the other cases of the Stockhill disaster, the factory. There's also been, sorry, I'm just going to look up my notes just to make sure. Apologies, as it's a complicated bill, I do have a number of papers. So you do have the Larkhall case and the Transco company, as I've mentioned, the Flying Phantom case, the Super Puma case, the Stockline case. Those are the big landmark cases that we've had in Scotland in instances that there is strong opinion they should have been prosecuted in a more robust manner that reflected the seriousness of the failings of the company. And I do have concerns that if we were to see anything like that happen again in the future in Scotland, the law is still inadequate. The level of the fines, while they may be significant, doesn't reflect the loss of life that has been experienced by families. And in the Transco case, it was described as a loophole. And there are other cases, the Stockline case, the judge in that case, Lord Brodie, said when he had to give it was tried under Health and Safety Work Act 1974. At the time, he said that response is by its nature an inadequate response. So I think there is recognition in Scotland that the law that we have in place isn't sufficient for the loss of lives that is experienced by families and the lack of care that has been taken by the companies. I'm going to invite Patrick Maguire in, if that's acceptable, convener, as I think he's indicating he'd like to contribute.
Yeah, thank you, Claire, and thank you, convener. Just to very briefly follow on from Claire's comments, what it really comes down to, in a nutshell, in terms of what Claire is saying, the name of the offence by which the person or the company is convicted really matters. It's that simple. It matters to the families who kissed a loved one goodbye and who never sees them again. It matters to them, and that's what we've heard from every single family that we've spoken to. Thompsons have been representing families who have lost loved ones to industrial neglect and recklessness for far too many years. But most importantly, in many ways, it has been seen that it actually matters to the authorities. As Claire says, when the Lord Advocate responded to the Transco disaster, he recognised that the name of the offence matters. That's why he did everything in his power to bring a culpable homicide prosecution that ultimately failed because the law was not robust enough. And as Claire said, Lord Brodie made similar comments too. It's recognised from the families, to the Lord Advocate, to the judges themselves, that the name of the offence matters, and that's what we need to achieve here. It needs to have the appropriate moral opprobrium, and simply a conviction under the health and safety regulations doesn't carry that. The families don't recognise it as such, and the law needs to respond to their needs and to, in fact, comments from our law officers and our judges.
Thank you. James, any further questions?
No further questions. Convener Patrick Maguire's covered my follow-up.
Thank you very much, James. In that case, we'll move on to Liam Kerr next, please. Liam.
Yeah, thanks, convener. Good morning. So listening to the answer to James Kelly there, Claire, you say that the gap is that a large business can't be prosecuted, but companies can be prosecuted currently, can't they? And so is it in fact what you're saying that the penalty, or as Patrick Maguire says, the name of the offence is the inadequate response? Is that basically your position here?
Yes, I think that would be a fair... While they can be prosecuted, it would have to be under health and safety legislation. But it's been impossible, Patrick can maybe come in on this, but it has been impossible to convict an individual. There's a difficulty of identifying who the controlling mind is within a large business and holding the organisation and the corporation accountable. The way in which modern companies are structured, the layers of management, it is difficult to identify who the responsible person is. And that was one of the reasons why there was difficulties in prosecuting the Transco case. But I will invite, if it's okay, convener, I will invite Patrick in to maybe address this.
Claire, may I just press you on that? Because as I understand it, that is the function of your legislation, in terms of the company piece, about the controlling mind. And is it not the case that one of the reasons there's a difficulty in identifying the controlling mind is that in the large PLC, there may not be a controlling mind? And one of the impacts of this bill, if it goes through, is that, and I see this in one of the sections, that you effectively could fix criminal liability and criminal penalty on shareholders, directors, a manager. This bill isn't going to solve the difficulty of identifying a controlling mind, is it? Or if it is, because there's no need for a mens rea, isn't that actually quite troubling?
I would, I think, disagree with the... I'll bring Patrick in, but I would, I think, disagree with the premise of the question. I think within a large corporation and a business, there is a controlling mind. There is a responsibility there, a duty of care over the people that work for them. And I'm not asking anybody to do anything here that they shouldn't already be doing. The health and safety legislation is there for a reason, and it is the employer's responsibility to provide a safe and secure workplace. And it would be for the Crown Prosecution Service to decide whether or not to take forward a case. But if somebody fails in that area, if a business fails in that area, I think there should ultimately be identified, there should be consequences. And it should be clear that the senior responsibility within the company are ultimately people responsible. People are working under their instruction in the company's direction. And it's not good enough for a company to say that they ultimately don't take responsibility. It was a more junior person within the organisation, if they are the people that are setting up the structure and the responsibilities of the way in which that company works. But if it's possible, Convener, I would bring Patrick in to maybe address the issue of mens rea.
Yes, please do.
Yeah, again, thank you. Just to address the issue of mens rea, firstly, Mr. Kerr, it's not the case to say that the bill as drafted will create a situation where there is no mens rea. That there will always be mens rea, as I'll explain in a second. I think it's helpful probably to take a bit of a step back and to look at the way the law has grappled with applying mens rea to companies over the years, in particular in the context of where a company's conduct or the agents of a company's conduct causes the death of an individual, particularly in the context of culpable homicide. Under the common law, as the Transco prosecution attempted to deal with, the only way that guilty mind, culpable homicide, could be applied to a company was through the fiction, and it was very much a fiction in the law, that the controlling mind of that company formed the decision-making process that led directly to the death. That was how a company could be seen to have formed mens rea, the guilty mind. The issue, of course, was that with anything other than a small company having a direct line, a connection between the wrongful act, the actus reus, the guilty act, and the decision, or more importantly, the controlling mind of that company, that the law said was the highest echelons of the company, the directors, in effect, meant that in all but the smallest of companies, it was all but impossible for that to happen, and that is the case. That is why in 2007 the UK government attempted to grapple with this and introduced the legislation that they did. They replaced, of course, one fiction with another. They removed the common law concept of the controlling mind and introduced a very similar statutory format where they required to use the generic and now not specific term, because it's a statutory provision, but for the guilty mind to require to be formed by senior management became the test. That, in reality, of course, presented pretty much the same problem, that when you're dealing with medium-sized companies, when you're dealing with large companies, when you're dealing with multinational companies, drawing a line between decisions of senior management and a wrongful act was often, or is going to be very, very difficult. And that's proven practically to be the case. And that's why I would suggest we've seen no prosecutions and we've seen no convictions under the 2007 Act. What this legislation does is say there's another way of applying a guilty mind to a company, one that reflects the reality of the way that companies operate in the modern world, companies of all sizes. What companies do, companies are non-natural persons. They can only act through natural persons, whether that is at board level, senior management level, supervisor level. And what companies do is they delegate down the authority to act as the company. And what we say is that if someone, a responsible person, as the bill has defined the individual, if a responsible person a person delegated down authority to a level of authority within the company, supervisor, manager, whatever it may be, if they act recklessly or they cause a death through a gross breach of duty of care, that individual forms the guilty mind, acting as part of the delegated authority. The company too is responsible because the company asked them to act. The company passed that delegated authority to them. And so the company is as guilty as the individual, and there is a guilty mind that can be tied to the guilty act, and the company in those circumstances should be capable of being convicted of culpable homicide. It is, on one level, a fiction too, but it's one that far more readily ties in with the reality of modern business.
That was a very full and lengthy answer. Thank you, Patrick. We're going to move on now to John Finney, please, who wants to pick up another line of questioning. John.
Thank you, Convener. Good morning, Ms Baker and Mr Maguire. At the outset, Conveners, can I, like James Kelly, advise that I'm a signatory to this bill, and I commend Claire, Patrick and the Scottish Hazards and the trade union movement in trying to reduce the level of unacceptable level of workplace deaths. In part, Convener, this question has already been touched on, but I want to revisit, if I may, please. And I wonder, Claire, can you point to any specific examples, and it is the Crown Office Prosecution Service, Procurator Fiscal Service, COPFS, sorry, I beg your pardon, who will initiate prosecutions. Can you point to any specific examples where prosecutions under the current law have not taken place or indeed been abandoned due to deficiencies with the present setup, and perhaps advise the committee how your bill might address these deficiencies, please?
It has been difficult to identify cases that the Crown Office may be considering taking forward, either under the 2007 Act or any other, or health and safety legislation. I suppose where I've come from is when I had the consultation process, there were families who came to me, and I had the event in Parliament, and a number of MSPs attended that event, where families, so they're not the big headline cases, but they are individuals who have went through a horrendous experience, and their feeling is the process they're dealing with is too slow, people aren't held accountable, they don't think the law works. I mean, one of the examples I had, from the consultation, someone says, nearly 17 years after the death of my dad, I welcome these proposals. No family should have to suffer as mine has had to. No one was held to account for my dad's death, and there was no prosecution whatsoever, and I was not informed why. I hope this attempt to change the law succeeds to help ensure justice is achieved for others suffering the loss of a loved one. As I remember, her partner died at work recently, and it was quite clear from the outline of the case that there was serious health and safety failings at that company, and she has concerns that
I don't know if I'm the only one who's losing Claire here. I think I'm not the only one who's losing Claire here. But John, you wanted to ask a supplementary. So can you ask a supplementary, and then I'll go to Patrick and see if Patrick can pick up where Claire left off and deal with any further issues you want to raise under this. John.
Thank you, Convener. Like you, I was wishing to establish that it wasn't simply my connection losing Claire. I don't know, perhaps Mr Maguire would be able to tell us, for instance, clearly, one of the functions the Crown can look at is fatal accident inquiries for work-related deaths. And I wonder if that would help put any numbers on where it might reasonably have assumed that, and I appreciate these are two totally separate functions, but I'm trying to establish where the deficiency in the existing law have meant that no prosecutions have taken place when one might reasonably expect them to have taken place. I don't know if you can help with that, Mr Maguire, please.
On Sorry. Yeah, thank you, Mr. Finney. On that more general point, I think Claire has already given the statistic that we understand there have been through the statistics that you're talking about, 250 fatalities at work since the Act was introduced, and there has been not one prosecution, nor has there been one conviction. So I think that would present one form of evidence. I would present another, and I'll try and be brief, and in fact can provide this in written format if it would assist after the meeting. But the Cabinet Secretary received a letter from Scottish Hazards asking the Scottish Government to support Clare's bill, and one of the Cabinet Secretary's senior team responded on his behalf. That letter suggested that at that stage, and this was before the bill was introduced, the Scottish Government thought the law was quite robust, despite the inadequacies that we have highlighted. More importantly, that letter highlighted 3 prosecutions against individuals under health and safety legislation. Those were the prosecutions of Donald Craig, Guthrie Melville and Robert Harvey. The Scottish Government's position was that because those 3 defenders received custodial sentences under the health and safety legislation, that must mean the law is working. I actually think those cases prove the complete opposite when we come back to what we're talking about in terms of the importance of the name of the offence and the appropriate moral opprobrium attaching to that offence. I've looked at those 3 cases in as much detail as I can, and as I say, I'm happy to provide a written submission to this effect rather than Mr. Chair suggest I'm going to speak at too much length again. Apologies for my earlier comments, but in my view, all 3 of those convictions, albeit yes, custodial sentences were eventually handed down, would have resulted in convictions under Clare's proposed bill.
Thank you, Mr. Maguire. Claire, did you have? I'm sorry we lost you there for some of that answer, but John Finney asked a supplementary that was directed to Patrick Maguire, but I don't know if between the two of you, Mr. Finney and Claire, you want to wrap this line of questioning up. Claire, have you got anything you want to add?
Yeah, I seem to have been disconnected, convener. Apologies for that. And I did catch most of Patrick's reply, and I think he referred to the Scottish Government letter that we received. And I was disappointed that the government gave an opinion that they feel the 2007 legislation is robust. And I would suggest the figures that we have in Scotland for continuing rates of fatalities at work suggest that that legislation is ineffective, and we do need a different approach taken in Scotland.
Thank you, Claire. John Finney, did you have anything further you wanted to pursue?
No, thank you. Content to leave it there. Thank you, Peter.
Thank you very much. Thank you very much. Liam Kerr wants to ask a quick supplementary. Liam.
Thank you, convener. Very briefly, just on that line of questioning, Claire, if I may, this bill at section 14 says it's without prejudice to culpable homicide at common law. Now, I think this is completely out with my professional training, but I think there are defences available to culpable homicide in the common law, which I don't see replicated here. What examination, if any, have you done of the interplay between this bill and what currently exists at common law?
As you say, the bill states it doesn't replace in any way the common law that exists with culpable homicide. And this bill is quite focused on trying to address the issue of inequality between individuals, small businesses and large businesses, and it is dealing with criminal law. I would suggest the issues that you've raised are important. If the bill was to proceed to stage 1, this might be the opportunity to give greater scrutiny to that kind of question.
Okay, thank you very much. Claire, I want to ask you about the issue of legislative competence, please. Several times in your evidence this morning, including I think 3 times in your opening remarks, you referred to this legislation, to your bill, as legislation in the field of health and safety. And as you know, under Schedule 5 to the Scotland Act, the whole of the subject matter of the Part 1 of the Health and Safety at Work Act is reserved to the United Kingdom Parliament. And we have, as you also know, a certificate from the presiding officer to the effect that your bill is out with legislative competence for that reason. So can you explain to us why you are seeking to pursue a bill about health and safety when the subject matter of health and safety is reserved to the Westminster Parliament and when the presiding officer has certified that this bill is out with our legislative competence?
I don't think I've referred to the bill as being a health and safety piece of legislation. I think I have compared the effectiveness of this bill to the existing health and safety legislation that I feel is inadequate. And I've said that the legislation should improve health and safety within the workplace, but I would counter that it's not a health and safety piece of legislation. That is a piece of legislation.
I'm sorry to cut across you, but can you just explain what that means? Because I don't understand that as neither a lawmaker or as a lawyer. How can a piece of law which is about health and safety not be about health and safety?
It's about equalising the culpable homicide law, which is the responsibility of Scots criminal law, that applies equally whether you're an individual, a small business or a large business. So one of the consequences of that, I would argue, would be improving health and safety, and it looks to address fatalities at work, but it comes within Scots criminal law. It's about amending it's about introducing the Culpable Homicide Act.
So what would you say?
And but I do accept, I do recognise the presiding officer's judgment, and I do accept there's an area here for debate. But I would also say that the Parliament, on previous examples, whether we look at minimum pricing for alcohol or we look at the Continuity Bill, there are times when the Parliament has taken the decision to push what we believe our responsibilities to be. That's not always been on a consensual basis, but we have taken the decision to push those responsibilities. And I think in this area there is different ways to look at this. I don't accept that it is cut and dried, that this is not a competent bill. I think that we should be ambitious and we should be brave enough and we should move forward with the legislation. And I think it is competent under Scots law. But I could bring Patrick in to talk about the area within the Scotland Act that we think this would mean the bill was competent, if that would be helpful.
Well, in a minute, we'll bring Patrick Maguire in a minute, but I want to pursue this with you a little bit further, if I may, and then Annabel Ewing wants to ask in this area as well. And then once we've heard from Annabel, then I think we'll bring Patrick in at that point, if we may. But Claire, I hear what you say about ambition, but I'm afraid that the terms of the Scotland Act don't talk about ambition. The terms of the Scotland Act talk about purpose and they talk about effect. And you've made it crystal clear this morning that the purpose of this bill is to equalise an element of Scots criminal law with regard to health and safety. And you've made it equally crystal clear that the effect of this bill will be to transform one area of Scots law with regard to health and safety. So both the purpose and the effect of this legislation are intimately tied up with health and safety, which is a reserved matter, as the presiding officer has explained in the certificate. So I completely understand the ambition, but ambition is an irrelevant consideration. The relevant considerations are purpose and effect, and both purpose and effect speak to health and safety, which is reserved.
I do understand the position that you're proposing, but it's not one that I fully accept. The sole purpose of the bill is to amend Scots law in respect of criminal law, and the pith and substance of the bill, as the consultation says, only relates to Scots criminal law. And I think that makes the case that it is within the legislative competence of the Parliament.
Okay, Annabel Ewing, and then after Annabel we can bring Patrick in if that's what Claire wants. Annabel.
Thank you, Convener. Good morning, colleagues and panel. Picking up on this issue, I mean, obviously I would be one that would be hugely frustrated with the constraints of Schedule 5 of Scotland, all of it in its entirety. I just wonder, I mean, obviously Claire cited other instances. I think in terms at least of one of the examples cited, you know, we had the Lord Advocate taking a very different view from the presiding officer. I'm not sure whether or not that is the position in this case. Looking at the issue, important issue, I'm hugely ambitious for us all. Looking at the important issue of workarounds, and it'd be interesting to hear, in particular from Patrick Maguire on this. I just wonder what attention has been given to finding a way round this conundrum. And in that regard, of course, there would be an element of caution in making that assessment, because, of course, the interplay of devolved and reserved elements has consequences as well under Schedule 5. So I just wonder, if there's a real intention to proceed here, because, of course, there's a risk, I guess, that in the PO's ruling, a legal challenge not be ruled out, which would not help these families. It wouldn't help anybody. So I'd be very keen to know if Claire is confident and her team that there is a reasonable workaround here that could be, in fact, the way forward. Thank you.
We are confident that Section 29(4) of the Scotland Act gives us the flexibility to move forward in this area. The purpose, for those that are arguing that reserved matters that it falls under the issue of reserved matters, we think the purpose of provision is to make the law apply consistently to reserved and devolved matters, and that the law of culpable homicide applies to individuals and non-natural persons alike. And we think within Section 29(4) of the Scotland Act, there is enough flexibility there for us to proceed with this. And as I said earlier, the bill has been presented 3 times. The first time it was presented by Karen Gillan, it was signed by Nicola Sturgeon and John Swinney, I think. I have had members I have 6 members of the government party who have signed the bill, as well as support from other political parties. I think there is a desire in the Parliament to see action on this, and a desire to take this as far as we can, and there are a fair number in the Parliament who believe that we do have the ability to legislate on this. And so I think for the committee to consider bringing the bill forward and giving it a stage 1 opportunity where this issue can be looked at and the argument can be explored, in which I will be proposing this bill is competent under the Scottish Parliament, I would be grateful if the committee were to consider that. But I know that Patrick would like to comment on the Scotland Act, but I know there's tight for time, convener. It would be your decision.
No, I'd like to hear from Patrick about this, unless Annabelle has any further questions first.
No.
Thank you. Patrick Maguire, please. Patrick.
I think Patrick maybe had problems with sound, convener.
I'm not sure if broadcasting can fix that or quite what's going on here at the moment. But if we can't hear from Patrick, perhaps we'll move on with the questioning and hope that we can reconnect. I think it was. Is he back? He's just gone from landscape to portrait on my screen, which is all very interesting. But anyway, listen, I think we should move on. Fulton McGregor had the next questions, and then if we can reconnect Patrick during Fulton's questions to Claire, then we'll come back to him after that. But Fulton McGregor, please.
Thanks, convener, and good morning, Claire and Patrick. Well, I want to start by thanking Claire for her opinion. It's unacceptable that we're still in this position. You know, every year in my constituency we remember the men who went to work at Auchengeek Mine in Moodiesburn, and this year, as colleagues will know, was the 61st anniversary. And as I said already, you know, it's terrible that 61 years later we're still having to talk about this issue. So thanks again, Claire, for your tenacity in this area. And also, please don't think because I'm not a signatory that I don't have a lot of sympathy and indeed general support for this bill. I think as the last bit of the conversation has been around, I've been interested in if this is something we're actually competently able to do or not, and hearing the arguments back and forward on that, and it's very interesting indeed. But on that note, you've talked about support from other parties, and I know that 6 colleagues from my own party have had are indeed signatories to the bill. Can you expand a wee bit on that? What sort of discussions have you had with colleagues across the 5 political parties? And also, has there been any discussions with government ministers or cabinet secretaries? Has there been any discussions in that area?
Thank you. As this is a members' bill, I do feel it's important to speak to people from all political parties and to provide opportunities for engagement. And I did hold an event in Parliament where families who had experienced the loss of a loved one at work came along and were able to speak to MSPs. And as I said, I do have the support of 6 members of the governing party, members from my own party. I had strong support from the Green Party, and Liam MacArthur, who's here today, is also a signatory to the bill. I did also speak to Liam Kerr, and I appreciate Liam has quite a deal of knowledge in this area, and we had a discussion prior to the bill being submitted. So I did speak to all the Justice spokespeople of the political parties within Parliament. And while Liam didn't sign the bill, I think we had a productive conversation, and it gave me some optimism that the bill could proceed through, but I would hope the bill would be passed, but it could proceed through changes and was introduced in a discussion that was important to have. In terms of the government, Scottish Hazards contacted the government on my behalf, and the letter that has been referred to already, I do have some disappointment about the government's defence of the 2007 Act and description of it as robust. I don't think the figures in Scotland reflect that. I don't think we haven't seen a decrease in deaths, and we have seen a peak in recent years. So I don't really accept the argument it's an effective deterrent. However, they do conclude by saying they would give careful consideration to the proposed bill when it's introduced, and they would look to see if the current legislation could be improved. So while the government haven't given a commitment to support the bill, I do have the support of members of the governing party, and the government have said they would consider it once it's introduced.
Thanks for that, Claire. A very full answer. And I know you've touched a wee bit on this already, but going back to when the presiding officer made his decision or his ruling on your proposed bill, what further advice did you take at that point that brings you to here today? And I know you have touched on this already, and you've already said at a stage 1 point you would be proposing that the bill is within the competence, but did you take any advice on that, and what sort of led you to continue on with the bill after the presiding officer's ruling?
As I've explored, the bill has been introduced 3 times, and the issue of competence has been in and around the legislation. I'm not denying that in any way. And the bill has had various support from members of different political parties as it's proceeded through. And when we decided to introduce the bill, I have had the support of Thomson solicitors because we anticipated the presiding officer's judgment on this, to be honest. It wasn't unexpected that the presiding officer took that view, but there are alternative views, which I understand Patrick is now back. We can maybe ask him to speak about Scotland Act, as I've mentioned section earlier, but there are alternative views, and those views are shared with people across the trade union movement and with the families who are supporting the bill, and with MSPs within the Parliament who think that we should take this opportunity to make these changes in the law, and that we do have the powers in order to defend making that decision.
Thanks, Convener. That's me just to simply say thanks again to Claire for all her work in this area. Thank you.
Thank you very much, Fulton. Patrick Maguire, I'm not sure if we have you back with us or not. We can see you, but we're not sure if you can see and hear us. But if you are with us, could you perhaps come back to the issues of competence that we were dealing with before we lost your connection? And apologies for losing you earlier. Patrick. We need to unmute Patrick's microphone, please. Can somebody in broadcasting please unmute Patrick's microphone, because we can't hear him at the moment.
Mr. Chairman, I've pressed the button myself. I'm sure that's not a normal procedure, but if it's okay, I'm happy to proceed.
Excellent. We can hear you, Patrick, so please continue. So we were talking about the legislative competence issue, and Claire wanted you to explain to us why, in your view, this legislation could be brought within the competence of the Parliament. So please.
Yep, thank you, and apologies for my signal dropping off. I, of course, heard everything that you had to say, Mr. Chairman, about the purpose and effect. I think it's important, however, to take a step back. A lot of the debate around this bill and previous iterations of it has centred on the consequential impact that it will have upon the health and safety environment in Scotland. There is a problem there that trade unions, campaigners, families wish to resolve, and that's why so often when bills like this, and Claire's bill is discussed, that is what is focused upon. However, and I think it's very easy to be dragged down that line of questioning and to focus only on that part of the bill. But both in terms of a pure ex facie reading of the bill, in terms of looking at the general purpose of the bill, in terms of looking at the carefully constructed policy document and explanatory notes, the bill does much more than that. The bill recognises that the law of culpable homicide generally is in need of reform, both in relation to how it applies to individuals and how it applies to organisations. That what the bill recognises is that there is an inconsistent approach in the way that the law deals with wrongful acts that cause death, as between both individuals and organisations, but also as between different sizes of organisations. And that what the bill seeks to do, most importantly, is to introduce two tests that apply to individuals and organisations alike, that levels the legislative test for culpable homicide, two tests that apply to organisations and individuals equally. And in that context, the reason why I'm labouring the two test point is because what the bill also does is recognise that Scots law has, over the years, had two different approaches to the mental element of culpable homicide, that many decades ago, and in fact longer than that, the test was principally one of negligence and gross negligence. The law then developed into the area of recklessness. There was a period of time when both recklessness and gross negligence applied equally as tests for culpable homicide. What this legislation does is return us to that point, that both for individuals and for organisations, it says that both tests are equally applicable, and that both tests should form the basis of a conviction for culpable homicide. And that's important because although there is a significant overlap between recklessness and gross negligence, there are gaps in between, and we recognise that that needs to be addressed both for organisations and for individuals. So our position is that what this legislation does is deal principally with Scots criminal law, and what it does is seek to make the law apply equally across organisations and individuals alike. We recognise that there is an argument that it impacts upon areas that are reserved to Westminster under the Scotland Act, but we argue that Section 29(4) of the Scotland Act provides the route by which the Act can be viewed as within the competence of the Scottish Parliament. Section 29(4), which says that a provision which would otherwise not relate to reserved matters, so, for example, perhaps impacts on health and safety, but makes modifications of Scots private law or Scots criminal law as it applies to reserved matters, which this legislation certainly does, is to be treated as relating to reserved matters, unless the purpose is to make the law in question apply consistently to reserved matters and otherwise. And that's exactly what this legislation seeks to do. And I think it was Ms Ewan that asked the question, or perhaps Mr Mackay, I can't remember, what further advice and views did we take in light of the presiding officer's statement on legislative competence? The answer is, disappointingly, despite the policy memorandum clearly stating that it's section 29(4) upon which we rely, a section of the Scotland Act that is completely untested. There's been no parliamentary discussion around it, and the presiding officer has not dealt with that at all in his statement of competence. And that therefore remains a live issue without any determination de facto from the presiding officer, because he's not dealt with the issue.
All right, thank you very much, Patrick. I hear what you say about section 29(4). It's not completely untested. There's a 3-2 split House of Lords or Supreme Court case about it a few years ago, where Lords Hope and Roger are on different sides. But Liam Kerr has one final question for Claire about this bill before we wrap this up. So Liam, please.
Very grateful, Convener. Claire, one final question. Isn't the Scottish Law Commission doing something on this, specifically looking at reform of this area? And if so, what stage is that at? Why aren't we waiting for that?
Well, the Scottish Law Commission have had culpable homicide on their sites for a while. It has only been added into the recent work programme, even though it has been on the agenda for a while. It's been pushed and pushed. It is finally in the work programme, which runs from 2018 till 2023. So they are considering culpable homicide, but we won't, at the earliest, have the report until 2023. And I'm not sure how that's been impacted by COVID and the pandemic, if that delays the work in any way. At that stage, we're only going to have their report. It will then be the government's job to reflect on that and decide whether to legislate or not. So we're looking at an extremely long timescale to address a problem that is already identified, and we're offering a route to solve it. And I think we can deal with this as a discrete issue within the Law Commission's review. And if the legislation is passed, it can be included within the Scottish Law Commission's review. But I think the timescales, I think we waited long enough, and the timescales for that report are too long and could be extended, and the time it will then take for government to legislate. If we look since 2007, as I said, since that legislation was passed, we have had some 250 fatalities at work. We had 29 people die at work last year. If we have to wait another 10 years, how many other lives will be lost in the time we're going to have to wait for the Scottish Law Commission to prepare the report and for a Scottish Government to decide to legislate, when we can actually do something now and take the steps to prevent fatalities at work in Scotland?
Thank you very much, Claire, for that answer. And indeed, thank you both to you, Claire, and to Patrick Maguire for all of your evidence this morning, which has been very full and very helpful. And the committee is very grateful to you. The committee will take this all away and discuss its approach both to this bill and to another member's bill in respect to which we took evidence last week. And we'll be in touch with you, Claire, in due course once we've decided how to take these matters forward. But thank you both very much for your time and evidence this morning. And that concludes the public part of our meeting today. Our next meeting will be after the parliamentary recess on Tuesday, the 27th of October, when we will begin our stage 1 scrutiny of the Hate Crime and Public Order Bill, by hearing from the Cabinet Secretary, Hamza Yousaf, the bill team that supports the bill, and also from Lord Brackadale and his officials. And we will also consider at that meeting our approach to the proposed Domestic Abuse Exclusion Orders Scotland bill and deal with some secondary legislation. That's on Tuesday the 27th. And we will now move into private session for the remaining items on our agenda. So members should please disconnect from Blue Jeans and reconnect on Microsoft Teams straight away. Thank you very much. Good morning.